This is our final case for the morning, the day, and the call. It is Price versus Austin. It's a 15-minute mini oral argument on the application. You each have 15 minutes. Ms. Tanner, you may attempt to reserve some of that for rebuttal, and if you're ready, you may proceed.
May it please the court, Heidi Tanner on behalf of the appellant Arthur Price. And I would like to reserve 3 minutes of time for rebuttal if necessary. The parties were asked to address 2 inquiries by this court. First, whether, sorry, I'm very nervous today. The first being, is it appropriate for a trial court or appellate court to weigh evidence and make a finding of fact and assess witnesses' credibility when considering the appropriateness of a motion for summary disposition under MCR 2.116C10. And if that is the case, whether it would be appropriate then to take these issues, the weighing of the evidence and the credibility from the province of the jury. It is our position that it is not. There is long-standing court case law wherein it says that parties can in fact, that a jury is to be, may I just take a moment? Sorry. Let me begin this way. When a plaintiff brings a case for a tort, i.e. an automobile accident, he is settled with the position of having to show that there is a duty, a breach of a duty, and damages arising from that breach. And in order for that claim to go through, if there is in fact a statute that is violated by the defendant, i.e. the driver in this situation, then there becomes a statutory presumption of negligence that is strengthened, and there is a rebuttable presumption that the defendant then has to overcome. So the burden then shifts to the defendant.
Ms. Tanner, why don't I interrupt you and let my colleagues ask you whatever questions they have, which sometimes is actually, less intimidating than just talking into a screen. And then if there's more time, we can get back to you if that's okay.
Thank you.
Yeah, you bet. Justice Cavanagh.
I don't have any questions right now.
Justice Welch.
I do have a question, Ms. Tanner. I am just wondering, one of the cases that's pretty preeminent in our jurisprudence about sudden emergencies is the White case. In that case, the plaintiff actually deposed the doctors, and their deposition testimony, that testimony actually called into question the suddenness of the medical emergency. And I'm just wondering if we have anything in our record sort of comparable to that, where we examined the defense through discovery.
Justice Welch, thank you. But no, we do not have a deposition of the doctor, but we do have the doctor's records. We have doctor records from Dr. Jonas, who had actually attended to the defendant 4 days after the accident. In addition to the first attending physician, wherein it indicated that Mr. Austin had indicated that he had suffered conditions similar to those that he complained of in his that preceded his heart attack 4 years prior to this auto accident. I did not find in my research that any case that indicated that we have to have a deposition of a doctor that would indicate that there was a conflict in the statements or a contradiction in statements between what was said at the scene of the accident, what was said by the patient at the time of admittance into the hospital or subsequent to. It just the case law in White just indicated that there needed to be shown that there are some conflicts or that there are some contradictions in the testimony that would lead a reasonable juror to the conclusion that there is not a true and fast path to saying that this was a sudden emergency. If reasonable minds can differ as to the causation of the accident, then that would be sufficient.
Thank you.
Justice Zahra.
No questions at this time. Thank you.
Justice Viviano.
No questions. Thank you, counsel.
Justice Bernstein.
Counsel, good morning, and I just want to say you're doing just fine. It's very challenging to do this by Zoom, and I think you're working through it just fine. So no need to be worried or concerned at all.
Thank you.
It's more of a comment than a question.
Yeah.
Justice Clement.
No questions. I agree with Justice Bernstein. You're doing just fine. Thank you.
Ms. Tanner, you have 9 minutes left. You may proceed and tell us more that you want us to know. You can also reserve time for rebuttal. You get to choose.
I would like to reserve 4 minutes for rebuttal, please. And I would like to actually highlight a couple matters here.
Great.
Relative to the sudden emergency doctrine, it is not an affirmative defense. What it is an excuse. It is an exemption as to whether or not a person's negligence can in fact be result in a verdict or a finding of fault. When a person is involved in a sudden emergency situation, they need to prove that this is a peril that was not of their own making and was not in their view for a long period of time. When Mr. Austin was driving, he had indicated in his testimony that he was coughing and that he felt like he was going to pass out all within a split second. However, later on, when he was speaking with his doctors, he had indicated that he felt a crushing pain, a twinging, a need to bear down, a feeling like he had to cough. So what we have here is, even though he didn't tell him that was within a split second, and he didn't say that he lost consciousness before or after the accident. And in the accident, he suffered a head trauma. And so without that question being posed to him by either one of his attending physicians after the accident, we do not know if the loss of consciousness or the syncopical episode occurred before the accident or after the accident. Now, with the sudden emergency, when you need to determine whether or not the peril was within a person's purview within an appreciable amount of time to allot them the opportunity to act as a person under similar and or like circumstances, we need to determine how much time was. We don't have a set time frame to make that determination. The court has never indicated that it has to be 5 minutes, 10 minutes, 20 minutes. What it has said is that whether or not there was enough time to take action. Mr. Austin, in this situation, had suffered a heart attack as indicated 4 years prior. He had indicated in those records that he had suffered symptoms similar to those that he described after he was being treated in the hospital, that he felt a crushing, sharp pain in his chest. This would then lead one to believe, a reasonable juror, that he would have had 4 years in order to appreciate the symptomology, and that in a person in his position while driving, starting to experience the twinging, sharp pain, causing him to bear down, it allows a person to now then think that he would have taken the opportunity to take evasive actions, that he would have more than enough time to act as a reasonable and prudent person. And that reasonable and prudent person standard is one that only could be decided by a jury, not by a judge. When a person such as Mr. Austin is giving his testimony, and it is based upon a self-serving, motivated testimony that is alleviate him from his negligence and liability and the liability and negligence of his employer, then that has to be taken into consideration also. It is a credibility issue. A credibility issue is only to be determined by the jury when in fact there is a conflicts in statements being made. And I think that the Wilmington test that was indicated in the brief is one that needs to be reviewed in this situation. And that can be actually found on page, I believe, 21 of my supplemental brief, where the court had indicated that we need to determine if the disputed fact is within the exclusive knowledge of the movement, whose supporting evidence is 2, subjective in character, and 3, upon which the burden rests. Clearly, Mr. Austin had a motivation to alleviate his negligence and liability in the situation. And when it becomes one where he is the only individual in the cab without any type of recording device, without anyone being able to give a third-party review or assessment of the situation, I would have to suggest and argue that that is an issue to be preserved for the jury, the trier of fact in this situation. Thank you.
You may reserve the rest of your time. Thank you, Ms. Tanner. Mr. Sangster.
Good morning, Chief Justice McCormack, Associate Justices of the Supreme Court. It's my pleasure to be here before you via Zoom on behalf of Defendant Austin and Ellen B. Cartage. Just as an aside, my last appearance in an appellate court live and in person was when I was in Lansing on March 11, 2020, arguing this very case. And I yearn for the day when hopefully we can get back to doing live and in-person oral arguments before this court and the Court of Appeals. As with Ms. Tanner, a little nervous doing this via Zoom. I've done it in other Court of Appeals matters, so bear with me if I stumble a little bit. This case is not about credibility. Neither the Court of Appeals nor the lower court weighed Mr. Austin's credibility. This case focuses on duty and the purported breach of duty, which is and always has been a function of this court to determine. The result that was reached by the Circuit Court and the Court of Appeals majority is consistent with the approach that our sister courts have used in the state of Ohio, Kentucky, and Tennessee, and indeed by this court in the Crashaw CASHAW case from 1951 and the numerous unpublished Court of Appeals decisions that were cited in our briefs to illustrate this principle. In this case, everyone agrees that crossing over the center line invokes a statutory presumption of negligence in violation of the traffic safety statute. In order to rebut that presumption, it's incumbent on the defendant to proffer clear, positive, and credible evidence of a sudden emergency, not of the defendant's own making, which renders him not negligent. That is precisely what we have done in this case. We have presented testimony from Mr. Austin that he had been making the same run for many, many years, that he'd never had any type of these syncopal episodes beforehand, whether driving his own truck or his personal vehicle. We presented evidence that, this was a dedicated run. He had no problems. He was on his way from Saginaw to Spring Lake. He had no problems traveling from Saginaw to Spring Lake earlier that day. It's about a 2-hour and 45-minute trip. The accident occurred on the way back from this dedicated run. There were no incidents from Saginaw to Spring Lake. He reloaded parts in Spring Lake. There were no incidents while traveling on eastbound I-96. No incidents while traveling on US 131 North.
Mr. Sangster, why don't I interrupt you and see what questions my colleagues have, and then we can get back to your presentation.
Sure.
There are none, if that's okay. I'll start with Justice Cavanagh.
I don't have any at this time.
Justice Welch.
No questions.
I do.
Sure.
So I can't find a single other jurisdiction that considers the sudden emergency doctrine as a question of breach, which is undoubtedly what Michigan does, that has ever dismissed a case as a matter of law like that. So that is not to say that I actually happen to believe, I know breach is normally, we think it's normally a question for the jury, and it sits comfortably as a question for the jury because there's usually a factual question to resolve. But I actually believe courts can dismiss cases when there's literally no question of fact as to breach. So I think you can. But it feels like in Michigan, this sudden emergency doctrine, which is a question of breach, has become a new kind of court-invented immunity doctrine. The only court that I can find that dismisses cases on summary is the Michigan Court of Appeals. I found 4 in the last couple of years. And in some of the jurisdictions in the cases cited in your brief, they consider the sudden emergency doctrine as a question of duty. I find that doctrinally a little bit loud. I don't understand it exactly. I think it sits more comfortably as breach where it is here. But why, if it's a question of breach, and in a case like this where the driver is driving on the wrong side of the road and may very well have a very good reason for it, right? It sounds like, according to his testimony, he encountered a sudden emergency. But why would it then be the court's job to dismiss it as a matter of law? Why isn't it exactly a jury question?
Because once we proffer evidence that it's clear, convincing, and credible that he was not negligent, that is, he was confronted with a sudden emergency, that presumption, that duty, if you will, disappears.
That's right. I agree. I absolutely agree. The sudden emergency doctrine can both rebut a presumption, and it can be a reason why a fact finder says no breach. So, for example, I could imagine a case with different facts where a driver's driving behind a truck and it's a logging truck and the chains come loose and the logs all come flying off the truck, and the driver swerves out of the way to avoid a log impaling his truck, hits another car. And there is all kinds of other evidence. Every other witness, says, logs were flying at his car, so he swerved to avoid the other car. That might be a case where a court might say, as a matter of law, there's no breach. Here we have a driver driving on the wrong side of the road, and the only thing we have to determine whether it was a sudden emergency is his say-so. I know the doctors took his word for it, probably for good reason. I don't question any of that. A jury might well say he wins, but I don't see why we have a case here where we should say breach as a matter of law. And I'm concerned that this doctrine is developing into some new court-invented immunity doctrine.
Because we have much more than just the defendant's testimony. We also have the evidence, physical evidence at the scene of the accident. There were no skid marks.
That's consistent with falling asleep. That's consistent with falling asleep or texting. That's consistent with lots of other scenarios. There's no other independent evidence that the reason he's driving on the wrong side of the road is the reason he says, right?
We have the fact that he veered off into a cornfield from 55 miles per hour down to 0 relatively quickly. We have the fact that he was unconscious in the cab. We also have the fact that while he was at the hospital, he suffered 3 similar syncopal episodes while at the hospital. And that physical evidence, coupled with his testimony, is what removes the presumption. And at that point, it's incumbent on the plaintiff to show something that he was negligent. For example, if you take a look at the Tennessee case that was cited in our brief, McCall versus Wilder.
It's duty in Tennessee. It's not useful. It's not useful. I think, but I take your answer. I take your answer. Thank you very much. Yeah. I'll let Justice Zahra. I don't want to hog all the time, so let me see who else has questions. Justice Zahra.
No questions at this time, thanks.
Justice Viviano.
No questions. Thank you.
Justice Bernstein.
Hi, counsel. Good morning. I really just kind of wanted to follow up on the Chief's questions, where that's kind of my concern as well, is that ultimately is that this would really appear, I mean, when you read Judge Gleischer's dissent, I mean, you and I can go back and forth and talk about kind of the intricacies of it, but the issue is, as the dissent kind of points out, there were inconsistencies, and we can talk about the level, nature, and scope of inconsistencies, but I guess my question to you, and again, it's just more of a follow-up as to what the chief was asking is, I mean, can there be no inconsistencies? I mean, if there's any inconsistencies, I mean, basically, at what level do we allow for this to then just become, almost like a strict liability situation where ultimately you just simply say that, okay, this is like a sudden emergency and whatever the inconsistencies are, jury doesn't have a chance to hear or take note of.
Again, the inconsistencies don't impact on the ultimate factor of what caused this accident. That is a sudden loss of consciousness.
Well, but I mean, he indicated that he hit the brake, and then he said he didn't hit the brake, and I mean, which definitely would go to the issues at stake. I mean, I guess I'm asking you to kind of look at this in a more of a general manner, which is, ultimately, I guess the question here is that where do I draw the line on this? I mean, you would simply say that there is just no question here whatsoever, and at what point, do we allow these cases to go to a jury or not allow for these cases to go to a jury? That's the question.
To allow a case to go to the jury, the plaintiff needed to do what the plaintiff did in the White case. And this was pointed out by Justice Welch on her questioning of plaintiff's counsel. In White, they developed factual evidence to dispute the testimony of the truck driver in that case that it was a sudden and unexpected loss of consciousness. We don't have that here, and that is a relatively easy test to apply. The minor inconsistencies that were recognized don't impact on the key point that he lost consciousness without warning. If, for example, plaintiff had deposed Mr. Austin's wife, who said, oh, he falls asleep behind the wheel all the time, or his employer saying that he was involved in a prior accident where he went off the road because he fell asleep, or got medical records that says patient experiences fatigue in late afternoon hours. That's one thing. That is enough to say, all right, well, that gives credence to plaintiff's argument that he fell asleep behind the wheel because he has a habit of afternoon fatigue, falling asleep behind the wheel. We don't have that here. What we have is, for example, what Ms. Tanner stated earlier, that, well, he had a heart attack 4 years ago. Simply having a heart attack 4 years ago does not mean that he had prior warning that this was going to occur. There's no expert testimony to that effect. In fact, we all know, we take recognition that we know people who've had heart attacks who are still capable of driving semi-trucks, box trucks, automobiles, motorcycles, what have you.
Thank you,
need
counsel.
something, Justice, you need something to say that this unexpected loss of consciousness was, in fact, not unexpected.
Counsel, I appreciate it. Thank you, counsel.
Justice Clement.
No questions. Thank you.
You have 3 minutes, Mr. Sangster.
All right. I would, in terms of the absence of evidence that I spoke about earlier, whether the court views this as a duty or what have you, I still think the approach in principle that was set forth by the Tennessee Supreme Court, even if it dealt with duty as opposed to what Michigan law is, I still think it illustrates why the lower courts below reached the right result for the right reason. If you look at the factors that were outlined by that Tennessee Supreme Court about what factual evidence needs to develop to refute, to show that he should have had prior knowledge that he shouldn't be driving a truck, we have, for example, the court says to examine the extent of the driver's awareness or knowledge that the condition that causes sudden incapacity. We don't have that here. This came on suddenly without warning. whether the driver had sought medical advice or was under a physician's care for that condition. We don't have that here. That could have been developed had plaintiff chosen to do so, but plaintiff did not. Whether the driver had been prescribed or taken medication for the condition prior to the accident. We don't have that here. Whether there was sudden incapacity had previously occurred, and I alluded to that earlier. We don't have that here. This was the first time this had ever occurred. Yes, plaintiff could have deposed perhaps family members or friends or employers to see whether or not he had ever experienced these episodes or episodes of falling asleep behind the wheel or fatigue after a long day driving, but that was never done here. The frequency, extent, or duration of the incapacitating episodes prior to the accident, we don't have that here. Again, it's a lack of evidence to show that he was negligent, that he should have foreseen that this event would occur. This was a sudden, unexpected emergency, not of his own making. Both the Saginaw County Circuit Court and the Court of Appeals majority reached the right result for the right reasons based on the record evidence in this case that, again, plaintiff failed to refute. Again, all plaintiff is hanging their hat on is this heart attack that occurred 4 years prior with no expert testimony to support that assertion. Plaintiff's claim, I respectfully submit, is based upon speculation and conjecture, which is insufficient under our court rules and our jurisprudence regarding summary disposition to get an issue before the jury. They've got to come up with something. They failed to do so here. Summary disposition was properly granted by the Circuit Court and affirmed by the Court of Appeals majority. Thank you very much for your time.
Thank you, Mr. Sangster. Ms. Tanner, you have some rebuttal time.
Thank you. Actually, we do have more than just saying that, he had a heart attack 4 years before. We have a medical record that shows what his symptomology was at that time. We have medical records subsequent to the auto accident, the subject auto accident, indicating that his statements became more prolonged, more explanatory. And the reason why is because Mr. Austin was sitting in the hospital wondering what exactly had happened to him. He was seeking medical treatment and he was concerned. And so when you have these type of conflicting statements, it raises a genuine issue of material fact for a jury to determine whether or not this individual had enough notice to take proper precautions while driving, to be reasonable and prudent, and what that reasonable and prudent standard would have been. When you have an individual who is, and we're talking about credibility. I mean, it says clear, positive, and credible evidence. Credible means credibility. So yes, Mr. Austin's credibility is at issue. Mr. Price's credibility is at issue. Every witness in this case's credibility is at issue. And when we're looking at the credibility, it is clear from our case precedent that that is an issue for a jury to determine. That is within the province of the jury. And the reason is because that there may be reasonable minds may differ. When we look at it becomes a slippery slope, because if you just take a driver's statements as God's given truth as to what occurred while they are driving and not look at anything else, then we now are allowing potential defendants to just merely say, well, I hit some black ice and that was a sudden emergency because I didn't see it. Or in the case of Champion versus Jenkins that I cited, that yes, it's not a published case and I attached a copy of it. But the court said that even though both the defendant and the plaintiff were given these statements and there could have been jurors that would say, yeah, that, there was these deer that were standing on the side of the road and as he approached, they jumped out and that created a sudden emergency, that another juror could have said he knew about those deer sitting on the side of the road and proceeded to drive. Reasonable minds can differ. And it becomes a genuine issue of material fact. There is no clear-cut set of facts here. And we cannot rely just upon Mr. Austin's self-serving statements. wherein he's motivated to avoid all liability. I do not believe that that the physical evidence that is being purported by the defendant it supports his claim that he had a syncope episode. He claimed that he had a syncope episode, but we don't know if it was prior or after the accident without any type of recording. Being at the hospital and having 3 subsequent syncope episodes does not mean that is not dispositive of the issue as to whether or not he had one before the accident. We know he had a head trauma in the accident, and syncope episodes can occur after. And so, again, I do not believe that this is that the Court of Appeals and the trial court were permitted to act as the trier of fact when it comes to Mr. Austin's credibility. I believe that it was resides within the province of the jury to make that determination, to sort out, to see the actions of Mr. Austin when he's testifying, his mannerisms, whether or not his memory develops any further, seeing that it developed a day after the accident and 4 days later. His story became more involved. And I think that a jury should be the proper trier of fact in sitting and looking at that.
Ms. Tanner, we have used up all your time and then some. Thank you very much for your argument today. Thank you, Mr. Sangster. This case will be submitted.
Thank you.
And that ends today's case call, this month's case call. See you next month, hopefully in person.
Thank you very much, Your Honors. Take care. Have a great afternoon.
Take care and thank you.